Okay, and welcome everyone. Today is Wednesday, September 4th. If you are watching us live, if you're on the replay, who knows when it is, but please join the comment section nevertheless. Those of you watching, please join the comment section. The chat if you're live. And while we wait for folks to file in, we will say hello to everyone who's here in the chat now because I appreciate you being here early. And then we'll get on right into it. Today's been a crazy, nuts day. I barely had time to sit here and turn the camera on. So it's crazy today. And many of you know that. So welcome in. And let me say hello to Is a God Thing. Welcome in Is a God Thing. Bonnie Kogenauer. Welcome in, Bonnie. Icy Cat. Welcome in, Icy. And Rebecca Ann, 1965, 1965. The awesome Rebecca Ann. Welcome in. It's a new day. It's a new day. One of my favorite YouTube channels here honoring us in the chat. Welcome. It's a new day. It's good to see you. Okay. Have mercy. Welcome in. Old Mort, new Mort. Welcome in. Commentator Root. Good to see you in and welcome. I can't see a conviction. There's so much reasonable doubt with the evidence I see right now, but if they have a bombshell evidence, I don't see it. Yeah, exactly. Well, you're pretty much hitting the nail on the head. And hey, it is what it is. All right. Welcome in, Marianne Foster. And yeah, I see a few of you in the chat. Everyone else, please join in. Now, we have so much, and you may have noticed the glitch in the introductory video. That's because my entire platform here crashed as it was playing. So I just lost all the documents I had lined up, so I'll be adding them as we go back into the rotation. Unfortunately, it glitched and crashed on me, but you know, that video you watched was a video I made quite some time ago, actually about 6 months ago, and I pinned the link to it in case you want to go back and read and watch. But that's a video explaining some things about fog reveal, and I think it's very important. And the geofencing as well. The geolocation, geofencing, all of that is important. We'll be getting into it today. But that's a video I wanted to bring back to your attention from 5-6 months ago. And it's pinned right there in the link that you see pinned. But that caused the all my PDFs to crash. So I'll be bringing them up one at a time. And matter of fact, let me get started on that now while we sit here. Let's see. Okay. No, that's not it. We're going to start with this one. Now, this was the order that came on down today from our unhinged, biased judge in the Delphi murders case against Richard Allen. And this thing right here is just it's a riot. This it's a hoot. And I'm sure many of you have seen this, but those of you who have not, guaranteed it's a hoot. You're about to find out. This thing here, let me read it for you because I know that's rather small text, but I'm dealing with a cheap to free software here, so that's what we're dealing with. But this is absolutely nuts, and it's nuts. It's nuts both in the way that she presented it and in the decision itself. I tell you what, I see nothing but psychological operations, public relations, gaslighting, and passing the buck in this entire scenario. This judge is just like the prosecutor and the law enforcement, just off the rails. In their attempts to railroad Richard Allen and to make all the other involved parties in the deaths of Abby and Libby go away, they're pulling out all the stops. And they basically don't care at all whether or not this goes into appeal and is overturned for the next 30 years or whatever. But they're trying all they can, just like the circus we saw after the leaks, which were caused by a handful of YouTubers, but blamed on the defense. Those leaks, yeah, those leaks. After those leaks, our unhinged judge tried herself to get rid of those really wonderful attorneys, Baldwin and Rozzi, for Richard Allen, and failed because the Supreme Court said you cannot do that. But she didn't give any care to that, and so she then had Nick McClelland attempt to do the same with a contempt filing, and if it was not for the awesome testimony of Julie Melvin and Skip Jansen, aka Stephen Wood, um, they would have been found in contempt. But Mr. Wood's testimony about the collusion of Fig Solves with a employee of the court stopped our insane, biased Judge Gold in her tracks, and she realized that she could not indeed go any further with that. So just as they were attempting all they could to remove Baldwin and Rozzi from the defense of Richard Allen, they're also trying now to not allow the jury to see anything in regards to this case other than the very limited and artificial fantasy world timeline and evidence against Mr. Richard Allen, and not allow him to put up a defense at all, and basically are going to railroad him into a conviction, which is the ultimate goal, because the thought is that if Richard Allen goes away as a lone wolf killer of Abby and Libby, then the entire case goes away, and all the eyes get off of the town, all the eyes get off of the corrupt law enforcement, the corrupt politicians, and the other parties involved in these murders, and the suspicious ass family. So we know that that's what's going on here. Anyhow, you'll see how she presents this is absolutely infuriating, and we'll get into the nitty gritty today. So I hope you have your comfortable seat, some kind of refreshment, because we'll be here a while. So let's start with this that came down today, this filing, or this order of the court. The court, having had the state's motion in limine under advisement following a hearing conducted August 1st. Yes, by the way, you do realize that we're 30 days beyond the date that you should have made a judgment on this. Whole other subject, though, with our lazy judge. And having heard and considered the evidence, admitted exhibits, arguments of counsel, defendant's supplemental submission regarding state's motion in limine filed August 13th, 2024, and the state's response to defendant's memorandum of law filed August 26, 2024, grants paragraphs. Now, I want you to really pay attention as to how this is pulled off here. So it's very odd the way she breaks this up. So she says, grants paragraphs 1 through 6 over defendant's objection, and grants paragraphs 8 through 12 over defendant's objection. As it relates to paragraph 7, okay, grants paragraph 7, but look at how she does it. So she's basically granting the entire thing, paragraphs 1 through 12, and we'll be taking a look at that. But she breaks it up into pieces to make it seem as it's sort of soften the blows here. Softens the blow. As it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism cult or ritualistic killing, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, Ron Logan, and the murders of the 2 victims. The case law is quite clear that the nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. Well, aren't the crime scene photos admissible evidence, Judge Gall? You know, the ones that show the sticks formed into rune formations on top of the 2 dead bodies of the girls, which the public at large has not seen, but which, if they should have the privilege of seeing, it would be absolutely certain in their minds that these are an attempt to form runic structures on the girls' dead bodies. But you're going to carry forward as if that's not what's actually there on the girls' dead bodies. Not to mention the clear runic attempt at a formation in one of the victim's blood on a tree. We're going to ignore all of this nexus of evidence that's right there at the crime scene, but that's a whole other subject. The case law is quite clear. The court finds the defense has failed to produce admissible evidence demonstrating a nexus between Odinism, cult of ritualistic killing, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, who did confess, Patrick Westphal, who blamed it on Brad Holder, who blamed it on Patrick Westphal, Ned Smith, Rod Abrams, Keegan Kline, who blamed it on Jerry Klein, who blamed it back on Keegan Kline, and Ron Logan, who suspiciously fled at the time this all went down and lied about his alibi. But none of this is a nexus of evidence. Okay, well, we'll see about that on the appeal, Judge Cole. Therefore, the court grants paragraph 7 of the state's motion to eliminate over the defendant's objection. So why didn't she just say? The court grants the state's motion to eliminate in totality, paragraphs 1 through 12. Why didn't she just say it that way? The court will not permit the evidence submitted by the defense in support of their arguments regarding third-party perpetrators in the trial of this cause, as the probative value of such evidence is greatly outweighed by confusion of the issues and its potential to mislead the jury. No, you don't want reasonable doubt in the jurors, which this certainly instills. The court will allow that evidence to support an offer of proof at trial is if one is made by counsel. Well, that's not giving anything because that's always there. So stop acting like you're doing anyone a favor, Cole. So basically, in summation, what we have here is that the defense cannot mention the following at all in the court. Any comments about counsel for the state that constitutes personal attack? You know, like McClellan has colluded with the judge and with Jerry Holman to totally allow the malfeasance on the part of law enforcement to railroad the defendant, Richard Allen, attempted to find the defense counsel in contempt because the initial try of that by Judge Gull failed due to the Supreme Court's intervention. She says also any comment which constitutes personal opinion of the defense counsel about evidence, witness outcome, or penalty, you know, like the lying witnesses, like the witnesses who don't make sense, and like the missing witnesses. I don't know. We'll get to that. For example, the defense cannot vouch for the truthfulness or competency of any state witnesses, including police officers or defense witnesses. You know, the police officers like Jerry Holman, lead investigator, who himself had clear communication with someone at Westville, probably the warden, Gallipo, suggesting or demanding that they remove the Odin patches as soon as he realized through his deposition that the defense was onto any sort of Norse pagan connection. We do not forget that within 5 days of the deposition of Jerry Holman, those patches that said, "In Odin we trust," etc., disappeared from the guards' uniforms. We do not forget that fact. Any innuendo or inference that isn't supported by admissible evidence, you know, like, I don't know, Elvis Fields had knowledge of the crime scene and confessed and also asked about what would happen to him if it was found that he spat on one of the girls. Remembering that we do have DNA from the crime scene that tends to be mixed with the victim's blood and is allegedly unusable, but we absolutely do have DNA from the crime scene. We also have fingerprints. Are you guys aware of that? Okay. Any attempt to expose the jury to substantive issues on the case? Any attempt to have the jury prejudice credibility of a witness? Any hypothetical questions that includes facts not in evidence or questions that aren't helpful in violation of Rule 705? Any attempt to introduce evidence of third party, including Odinism, ritual cultural killing, cult killing, Brad Holder, Patrick Westphal, Johnny Melser, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, Ron Logan. Hey, guess what? Remember, it was not the defense who invented the idea that Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams might have been involved in this. It was not the defense who invented the fact that Keegan Kline, Jerry Klein might have been involved in this. No, it was not at all. It was law enforcement itself. Who is law enforcement? Law enforcement is FBI. Greg Ferenczi, who was assassinated in front of his office, oddly enough, before he was able to see this trial. Yes. Law enforcement is Todd Click. People tend to forget or want to muddy the waters and feign as if the defense invented this entire scenario. No, this all comes from the discovery. Todd Click's information, Greg Ferenczi's information, all the information on Odinism, the actual fact that they're wearing Odinist patches, the actual fact that we had Robert Bastin pen a letter to law enforcement or to the court or to the higher ups, I should say, stating that John Gallipo, warden of Westville, was himself the leader of the Odins, as he put it, and that Richard Allen was being threatened by both the guards and other inmates. But the troll farm wants you to believe that the defense made this up on a whim and figured, hey, what's the best defense strategy we could come up with? Oh, I don't know, that the girls were sacrificed in a cult killing. Well, do you remember that in the short time that Baldwin and Razi were out of the case, that you had Scrimmin and Libredo, attorneys appointed by Judge Gull? And do you remember that when Libredo came out of that situation once Razi and Baldwin were reinstated, that he himself said one was murdered, one was sacrificed? So if Baldwin and Razi made this up out of their imagination because they live in fantasy world and they imagined that the best defense that would be easiest to convince a skeptical public was that the girls were sacrificed, why do you think Libredo would come out of having his hands on the discovery and say the same thing? Okay. Any reference to an investigation by Todd Click cannot be included. Any reference to geofencing and or testimony from Kevin Horan about geofencing or the findings from any geofencing. Now, you want to talk about that? Because that's an absolute unfathomable situation. That law enforcement, who themselves rely on a daily basis on digital forensics for both investigating and prosecuting crimes, for some magical reason, in this case, foregoing the fact that they've lost 70 days of interviews, investigation, the entire first week, they never took digital forensics from the family's cell phones, which would be essential in determining a timeline and establishing it, putting down mileposts or markers forensically, digitally for a timeline. No. This prosecutor in court doesn't want any of their own geofencing or digital forensics in the case. Makes you wonder why, doesn't it? Okay. Also, any reference to prior bad acts of witnesses. Any reference to how the rules were labeled that were handed over. So even though they negligently and combatively, with malfeasance, handed over partial discovery, they don't want that mentioned either. And they don't want any reference to PowerPoints that law enforcement itself used, or any executive briefs that were used by law enforcement during the 6 years. Does it sound like a railroading to you yet? Okay, so clearly you see what this is. Okay, clearly. Now, there's a lot to get into. So Let me next bring this up. And sorry, it's not good to go at the split second. Uh, this is all on the fly because I'm having to re-upload. Let's see. Here we go. So let's take a look at this motion, which was awarded in totality today, although with confusing verbiage from our insane biased judge in this case that is hell-bent on covering up the murders of Abby and Libby, probably because it has ties to the entire community structure and the elite in the community and would take down an entire community, and they don't want that. That's the assumption, right? Allegedly. Okay, this was the initial motion in limine that our crazy Masonic slimeball attorney, prosecutor, who refers to himself as Nick. Okay, here's Nick's motion. He doesn't want, we just summarize this, but you see, he doesn't, number one, he doesn't want personal attacks on the attorneys. He doesn't want opinions of defense counsel about anything at all whatsoever. No opinions. No innuendos or inferences. So no opinions, no innuendos, no inferences. Boy, he's really muzzling these defense attorneys, is he not? Any attempt to indoctrinate the jury. How do you do that? How do you indoctrinate a jury? Just explain that one to me. Are not they capable? That's why they've been chosen to be jurors. They're capable, adult, sensible human beings who have the ability to reason and decide the fate of a man. But they're so infantile. You have to delineate in here that the attorneys cannot attempt to indoctrinate. No prejudging the credibility of a witness. Oh, really? What about these young girls who do not even have consistency on what they saw, who do not agree to the sketches about what they saw, and the one who does agree that the sketch is a 10 out of 10 says it's not Richard Allen? What about that? But no talking about the credibility of the lying ass witnesses and the missing Daniel Pearson and what's her name? The girl he was out there with. Okay. Let's see what else we're looking at here. Number 6. No hypothetical questions that include facts that are not in evidence. Oh, so no saying something like, Keegan Kline said Tony killed the girls, and he waited in a vehicle and for about 2 hours, and when Tony came back, he was bloody and said, "We had fun. Now come help me move the bodies." No mention of that. Why? I don't know. Also, Keegan saying that he threw a weapon in a river. No mention of that. Okay, well, odd enough. Because see, we don't have a murder weapon, do we? Yeah, maybe because it's in the river where Keegan threw it. Okay, so any attempt to introduce evidence of third-party motive. Okay, and you see here, Odinism, cult ritualistic killing, Brad Holder. Brad Holder, who points the finger at Brad Westfall, who points the finger back at Brad Holder, and Johnny Messer, who Elvis Fields points the finger at, and Ned Smith and Rod Abrams, who happen to be involved in a situation. Keegan Kline, who points the finger at Jerry Klein, who points back at Keegan Kline, and they both being family friends of Ron Logan. No discussing that. No reference to Todd Click, even though his partner was assassinated in front of his office, oddly enough. No reference to geofencing or testimony about geofencing or findings from any geofence. Why would a prosecutor ever ask for that? Ask yourself. No prior bad acts of any witness. Oh, you mean like the meth dealers? So we can't. So when this for 7 years has been alleged to have been a meth involved situation or potential how should I put it, Prof? How should I put it? Murder for hire. Okay, if what we indeed had was a something like a hired hit from one meth dealer to another, if this was a hired hit, like Jerry Holman once believed it was, uh, if this was a hired hit, like Jerry Holman once believed it was, would not both parties be involved in some sort of illicit activity? Possibly meth dealing, possibly CSAM, child trafficking. But you don't want us to talk about that. That cannot be heard by jurors because we cannot let the jurors hear the defense of this case. No, we cannot. All right, so where are we? No reference to how the law enforcement, or the state, I should say, combatively and in a suspicious way dripped discovery in a disorganized fashion out to the defense counsel. No, we can't talk about that either. Okay, so what else do we have here? All right, it's going to take me a moment. Apologize. All right, defendant's supplemental submission regarding motion in limine. Here's where the meat and potatoes, where the rubber meets the road here. Paragraph 7. This is the big one. The state's motion in limine, number 2 at the bottom here. Seeking or sought to further restrict defendant's Sixth Amendment right to present his defense by way of limiting investigative records generated by former police officer Todd Click and geofencing records generated by the law enforcement investigators. On or about August 1st, parties appeared in court, at which times both sides introduced evidence in favor of their positions regarding third-party culpability. The court took issues surrounding third-party culpability under advisement. Now we know the order has been issued. The defense requests this court take judicial notice of the record of proceedings held on November 22nd, 2022, and attached hereto as Exhibit A. One of the primary issues addressed at the November 22nd, 2022 hearing was the state's request to maintain confidentiality of the PCA, charging information, and other investigative records. At different times during the hearing, the state of Indiana, by Prosecutor McClelland, spoke the following words. I want you guys to prick your ears up right now. Prick your ears up. Please get the wax out of your eyes and the cotton out of your ears. According to Nick McClelland, this is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. That is the public interest, to find anyone else involved. We have good reason to believe that Richard Allen is not the only person involved in this case, says Nick McClelland on November 22nd, 2022. That there may be other actors involved on November 22nd, 2022. That's why we left the tip line open to this very day. That's why we left the tip email open to this very day. The question becomes, at least in the state's mind, is it more important to release details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible on November 22nd, 2022? It puts the investigation in the best position possible to determine if anyone else was involved on November 22nd, 2022. It's in the best interest of the public that the investigation find anyone else involved, he said on November 22nd, 2022. Yeah. So what happened? Huh? I want you to look at something else. Let's see. Sorry about that. Okay, let's take a look at this. This is a transcript from the Down the Hill podcast. Down the Hill podcast, chapter 10, episode called 4 Years. Okay? This is Tobe Lesenby speaking. So the question is, back in April, you mentioned perhaps a smudge fingerprint. Is that a piece of evidence? Tobe says, there were some fingerprints collected. Yeah. So, I mean, but again, practically every crime scene has got fingerprints. For the most part, unless they're wearing gloves or something. Question, do you know if those fingerprints belong to the killer? Answer, that I do not know, says Tobe Lesenby. And the same with DNA. You have DNA. Do you have this? Do you have his DNA? Yeah, we don't know. We haven't. No one's charged. No one's jailed yet. Okay? Down the Hill podcast, part 10. We also have this from an article in the Carroll County Comet. Okay, this article is titled Lots of Tips, No Arrest in 2017 Double Homicide, April 29th, 2020. You got it? April 29th, 2020. The quote is that Lesenby advised there is DNA from the crime scene, but refused to divulge where it originated. He said there is, quote, suggestive evidence of fingerprints found at the crime scene. This is not simple, he said. This is not television. DNA can come from all sorts of places, and fingerprints can be smudged and hard to identify. So there is absolutely no question whatsoever. We have DNA and fingerprints. You heard both of these from Tobe Lesenby himself. Do you remember the anecdote? Who remembers? Raise your hand in the chat. If you remember the anecdote about a fingerprint being put on the trunk of a car or something to that effect, or on top of a car, the car being driven off and the fingerprint blowing away and losing evidence. Who remembers that? Do you guys remember that? That little rumor, that word on the street? Is this part of that? Who knows? And obviously the state does not care. All right, so here we go. From the motion to compel, March 2024, paragraph 29 through 35, I'll read it for you. The very last discovered item that the defense received before the prosecutor requested that the defense be kicked off the case because Judge Gold didn't get what she wanted, so she had Nick McClellan do a second try, was geofencing evidence that the defense believes was received on October 6, 2023. This geofencing evidence was received nearly 10 months after the state was required to turn it over and contained what appeared to be highly exculpatory evidence concerning a variety of important matters, including the phone numbers of multiple people who appear to have either been at the crime scene or within 60 to 100 yards of the crime scene during the very times when the victims were purportedly being murdered, according to the state's timeline provided in the PCA. In this late discovery, the defense found a map prepared by somebody, presumably law enforcement, who appears to track the movements of these people in and around the crime scene the afternoon of February 13, 2017, including between 3:02 p.m. and 3:27 p.m. at or very near the location within 60 to 100 yards of where the bodies were ultimately found the following day. What are the odds of that? Since their return to Richard Allen's defense, Allen's attorneys have specifically requested via email that the state of Indiana provide all narrative reports related to the geofencing data, as well as the documents related to the geofencing data. But the state of Indiana so far has claimed that no such documents exist. Again, the defense is at the mercy of the prosecutor's claims of existence or non-existence of evidence. As it relates to the geofencing evidence, it would be shocking that law enforcement would take the time to put together a map tracking the movements of certain phones in and around the crime scene between 12:39 p.m. and 5:49 p.m. on February 13th. Yes, you heard it again. Between 12:39 p.m. and 5:49 p.m. on February 13th, 2017, but not follow up with the detailed narrative reports concerning the geofencing analysis of the data. Yet the prosecution claims no such geofencing reports exist. However, the defense has heard this type of answer from the prosecution in the past, only to learn that the prosecution's claims that documents did not exist were not true. Yes, it shows malfeasance. Amended motion to compel and request for sanctions. This is March 17th, 2024. I suggest you go download this. March 17th, 2024. Amended motion to compel and request for sanctions. Please go and download it for yourself. This is impossible to find and you need it. Comes now Richard Allen by counsel. Baldwin and Razi amends the motion to compel and request for sanctions filed March 12th. In support of said motion, the accused states the following. On March 12th, the accused filed his motion to compel the state of Indiana to provide certain answers concerning the existence of certain discovery, and if it existed, to provide the actual discovery. On March 8th, 2024, the state of Indiana did in fact provide some of the answers to some of the questions concerning some of the discovery. Counsel's unawareness of this response is a result of the flurry of communications and filings that have occurred between the state, the defense, and the court since Attorney Baldwin and Razi were reinstated by the Indiana Supreme Court, because they had to force this crazy judge to do the right thing. However, there's still outstanding discovery that the state of Indiana claims does not exist, when common sense causes the defense to believe that the evidence must exist. Therefore, based upon the state of Indiana, March 8, 2024 correspondence answering a certified letter overnighted to the prosecution on February 20th, 2024, the defense can pare down its request concerning certain documents, as the state of Indiana has answered certain questions concerning certain discovery previously found in paragraph 69 of the motion to compel and request for sanction. Therefore, the defense would amend paragraph 69 of the original motion to compel and request for sanctions and ask the court to compel the state to produce the following. The state of Indiana provided two undated reports never seen by the defense. One, the first report provided some detail as to how the state of Indiana explained that certain videotaped recordings between February 14th, 2017 and February 20th, 2017, which would include Holder's interview, were erased. Therefore, the request has been satisfied. Remember, the first full week of interviews erased. However, the other report details how all videos between April 28th, 2017 and June 30th, 2017. Is that a long time or not? April 28th to June 30th, 2017. Lost all videos. This is news to the defense, as the defense was unaware that certain videos did not contain audio, but was unaware that videotaped interviews between April 28th and June 30th were missing. This is most concerning. Additionally, it appears to the defense that the report is incomplete, as it details attempts to recover the lost interviews, including purchasing some type of equipment from China to assist in recovering the lost interviews. However, this is where the report ends. It's unknown whether the equipment from China was ever purchased or if an attempt was made uh, to recover the missing interviews. Based on paragraph 5A2 above, the defense requests the court to compel the state of Indiana to provide complete report of law enforcement attempts to recover the missing videotaped interviews. Based upon paragraph 5A2 above, the defense would be requesting the court to compel the state of Indiana to provide a listing of all persons whose interview was videotaped but lost. But unfortunately, according to the state of Indiana, there's no comprehensive written log that was used to document data. To document the date, time, subject, and participants for each interview room. The defense seeks supplemental information as to which law enforcement individuals may have interviewed suspects and or witnesses during that time period, and any reports reflecting the occurrence of such interviews and summaries thereof. Again, it is extremely concerning to the defense and Mr. Allen that potential exculpatory witnesses and statements are apparently forever lost, and not even a log of which witnesses were interviewed exists. Furthermore, it is very disconcerting that the defense just learned of this lost evidence, and only upon request of the defense of such a report, and more than 14 months after the defense should have learned of this lost evidence. Totaling the missing days of interviews, February 14th to February 20th, 2017, and April 28th to June 30th, 2017, put your ears on, which show that the state of Indiana has lost 70 days worth of interviews. And not just interviews, ladies and gentlemen, recorded interviews. And claims to have no ability to fully account for who was interviewed during those 70 days. I have to ask you, ladies and gentlemen, to consider, was this accidentally lost? Or was this intentionally destroyed? Let's reiterate. From February 14th to June 30th of 2017, that's the first several months of the investigation, gone. Recordings, gone. Notes, summaries, gone. List of who it was, gone. Nothing. In its March 8th, 2024 response, the state of Indiana failed to produce similar reports explaining how the audio is missing on certain interviews. The defense would request the court compel the state of Indiana to issue a report detailing why no audio exists. In response, the state of Indiana claims that no phone dump. Look at number 8, please, ladies and gentlemen, center of your page. In response, the state of Indiana claims that no phone dump evidence exists from Kelsey German's phones, nor Mike or Becky or Cody Patty's phones, and furthermore, that the prosecutor's office does not possess any phone dump data from those phones. And we're going to prove it to you in a moment. However, it's still unknown whether that phone dump evidence did exist at some point in time. Which question is more than fair, considering the loss of 70 days of investigative activity as referenced before, and videotaped interviews? It would be hard to believe that law enforcement would not have obtained the phone dump data from the parties identified in this paragraph, Kelsey German, Mike and Becky Patty, and Cody Patty, to at least determine timelines. Because the state of Indiana has lost other important pieces of evidence, That is 70 days worth of videotaped interviews during the first 4 months of this investigation. 70 entire days of videotaped interviews. The entire family's phone forensics. The defense would therefore ask the court to compel the state of Indiana to answer as to whether the phone dump data ever existed, and if so, what came of it. The defense would compel the court to order the state of Indiana to provide all geofencing data and the names of the actual person or persons that interpreted the geofencing data, including the person or persons that reduced the geofencing data to a map that has been provided to the defense. In preparing for trial and for a contempt hearing and reviewing newly discovered evidence, the defense and its limited staff has had limited time to fully review the state of Indiana's response and compare it to the request of the defense. However, for now, the defense would request the court to compel the state of Indiana to produce the items detailed in paragraph 5 to 11 above. And I reiterate, you guys need to go find this and get it. This is a amended motion to compel and request for sanctions, March 17, 2024. Now, on to the good stuff. March 8. Actually, let's back it up. Well, we'll just go with this. We'll go with this. Let's read this. Description: undated report regarding missing videotaped recordings between February 14th and February 20th. Okay. The report provides some detail as to how the state of Indiana explained that certain videotaped recordings between February 14th and February 20th were erased. Amended motion to compel and request for sanctions, page 1 to 2, paragraph 5, subparagraph A 2 to 3. March 8, 2024, undated report regarding missing videotaped interviews between April 28th and June 30th, 2017. This report details how all videos between, guys, perk up your ears, all videos between April 28th and June 30th, 2017 were also lost, but is incomplete as it details attempts to recover the lost interviews, including purchasing some type of equipment from China to assist in recovering the lost interviews. However, this is where the report ends. It's unknown whether the equipment from China was ever purchased or if an attempt to recover missing interviews was attempted. All right. And here you go. This is the actual email from Baldwin and Rozzi to McClellan, March 7th. Subject: discovery regarding certain phone dump data from certain phones. Nick, please provide phone dump data from Kelsey German's phones or Mike or Becky or Cody Patty's phones. Signed, Brad and Andy. From Nick to Baldwin and Rozzi. March 7th, 2024. Regarding discovery regarding certain phone dump data from certain phones. Gentlemen, here at the bottom, the prosecutor's office does not possess any phone dump data from Kelsey German's phones, nor Mike or Becky or Cody Patty's phones. Signed, Nick. So let me ask you that, you good people in the United States of America and all over the world here. How on earth, how in hell do you establish a timeline forensically with no cell data from Kelsey, Mike, Becky, or Cody Patty? I mean, are we in a twilight zone here? Are we in fantasy world here? Are we meant to believe that you're going to take a single pass of a vehicle on a camera and the family's word for a timeline? That's how you're going to establish a timeline? As I've said many times, how do you know if that vehicle is coming or going? How do you know if Kelsey's vehicle is coming or going? How do you know if Richard Allen's vehicle is coming or going? Why would you not take the person that delivered the girls to the trails, allegedly Kelsey German? Why would you not get her phone, do a dump, nail down where she was when she was? I can't understand. You see, this is so much worse than we ever talked about before the arrest of Richard Allen. All the years the people have questioned the family. Is there any wonder why? Because it seems like what investigators would do is they would take the entire family's phones immediately, extract the data from all the phones, and possibly with Kelsey's phone, if she was allegedly the one who dropped off the girls at the trails, seems like they would have kept that phone permanently. How do you prove where anyone was and when they were there? Oh, but you can't ask these questions because asking these questions makes you a family basher. And God forbid you be a family basher. How are you going to prove to me when those girls arrived at the trails? Because if you can't prove it to me, you can't prove it to a juror. Not only that, do you not think the jurors are going to ask the question, is that vehicle coming or going to the trails? I'm not making this shit up. None of us made this shit up. When for years we said we did not trust the ever-changing stories of the family members and the always suspicious body language of the family members, there's a reason we said that. And now you have a prosecutor, a law enforcement, and a court that appears to be covering up these crimes and railroading a single individual. And you're going to say you don't have 70 entire days in the first 3 months? I mean, what percentage is that? Can we do some fucking math here? 3.5 months, 70 days. What is that? Like, I don't know, 2/3? So 2/3 of the first 3.5 months, you don't have a single thing? You don't have the family cell phone extractions to be able to nail down a timeline and who was when and where and what and how? I mean, this is what crazy making is. How in the world do you expect people not to be furious? Sorry, I have more. There's more. I must find it. I'll just read you this next one. The defense received certain geofencing evidence that at least 3 persons were in or around the crime scene at the time while the murders were taking place, according to the law enforcement timeline. And none of the owners of the phone have any connection to Richard Allen. This geofencing evidence would provide evidence of any of the following scenarios. A, those persons walking with the phones are witnesses that would have observed the murders as they were taking place, and none of them have identified Richard Allen. Or B, those persons walking with the phones were witnesses who observed nothing, as the murders did not take place the afternoon of February 13th, 2023. I'm sorry, 2017, typo here. But the victims were taken to the crime scene after the search was called off. C, those persons walking with the phones were participants in the murders. Paragraph 10. Said geofencing evidence was so important to somebody in the investigation that they created a map and plotted the movements of these persons, including movements that show that at least one of these persons was within 60 to 100 yards of the crime scene at the time while the murders would have been committed according to law enforcement's timeline. The phones, once again, had no connection to Richard Allen. Furthermore, the map shows that the other 2 phones and the persons carrying those phones were in and around the crime scene between 12:39 p.m. and 5:49 p.m. This is from a document called, where is it? Oh, gee willikers. Sorry, I lost it. Get right back to it. I want you to know which document that was from so you can go and read that one yourself on the replay if you choose to do so. Okay, that document is called Richard Allen's Third Frank's Notice and Request for Frank's Hearings based upon newly discovered evidence and request for findings of facts and conclusions of law upon any ruling of this request. Quite a title, isn't it? That's March 13th. Okay, March 13th, 2024, Richard Allen's Third Frank's Notice, etc., etc. That's where I just read from, and like I said, I read paragraphs 8 through 11. Okay. Now there's one more anomaly. Remember, our victim's phone stopped pinging and started pinging again. No matter what they will tell you, the absolute bottom line fact is that means the phone was powered off. in the 5 o'clock hour. It also means that in the 4 a.m. hour, the phone was powered on. You tell me. Who powered that phone off if Richard Allen was home? Who powered the phone on at 4:30 a.m. if Richard Allen was home? Not only that, have you heard of the classmates, the little girls? The classmates? Our classmates initially said that they left at 3:30 p.m. I'm getting confused because I'm excited in a bad way. Okay, our classmates. I want you to really think about this. The classmates originally said they left at 3 p.m., then changed the story to we left at 3. I'm getting backwards. They originally said they left at 3:30 p.m., then changed the story to we left at 3 p.m. Well, hello. Let me find those. I'll give you a few quotes before we get on from here. Sorry, it's taking me a moment. This computer's lagging today. Okay, so that's not it. I'm going to give up. I'm going to give up. I'm going to give up on quoting it. Pardon me. Yeah, true story. Ron Logan said approximately 1 p.m. victims are dropped off, which really means Libby's phone arrives. Um, so you got the classmates. You got Daniel Pearson. Okay, I don't know if you can see that well or not. Sorry about that. See if you can see this better. Daniel Pearson I want to say I was sitting on the bridge at 3:19. Well, shit. Isn't 3:19 between 3 and 3:30? So you had the classmates, You had Daniel Pearson. You had his associate. You had Rayleigh Voorhees and her little sister. Why do we never hear from her? I mean, surely any of you who have been out there know that there's no way you're not going to see someone in that vicinity. You'll see them from 150 feet away. Does she see nothing at all? I mean, what else? What else? We have. Sorry, I'm stumbling a bit for. I want to get things right when I quote them. I don't like just top of my head. I want to read it so that I quote it accurately. I remind you that Fire Chief Darrell Sterrett and his crew stated they blanketed the entire area near the Monon High Bridge more than 3 times between 5 p.m. and midnight. Darrell, sorry, Darrell. Chief Darrell, Chief Sterrett, you blanketed the area. You didn't see those girls on Ron Logan's? Eric Williams and Joseph didn't see those girls at Ron Logan's? Anyone else with the slightest bit of common sense who would have went down that trail and ended up down at Ron Logan's? No one saw those girls? Between 5 whatever and 4 a.m. Is that why that they weren't there? Is that why the phone was turned off? Was the phone turned off to remove them out of the area? And was the phone turned back on once they were delivered? I mean, someone has to make it make sense. But how in the world do you have a prosecutor who does not want the geofencing that shows 3 phones right where everything's going down, none of which is Richard Allen's? Somebody explain it. Somebody explain it, because I cannot conceive, and I have thought of a lot of crazy shit in my life. I mean, was it Daniel Pearson's and the classmates' phones? Was it the killer's phones? Was it some family members who weren't supposed to be there at that time? I mean, who's in the geofencing? Who did the 3? Okay, fuck it. Who do the 3 phones belong to that are in the geofencing that they don't want in this trial? I titled the show Done Lost Their Damn Minds, because they are so blatant with what's being attempted here that the only thing I could possibly imagine is they've lost their damn minds. I said that when I got to show number 100, I was quitting the live streams. Well, ladies and gentlemen, today is episode 99. I've got some thinking to do. They done lost their damn minds. And I don't know how to say it any other way. But there's so much here. There's so much. Who's being protected? Who are they protecting? What's up, Jennifer? Let me say hello to everyone in the chat while we're here before we leave. We got Carol, Radar, Untamable, Jennifer Dixon, Four Pits, Have Mercy, Kayla, Digital, CSM8119, Adrian, Rebecca Ann, Kayla, Four Pits. Thank you, Leads with Love. Leads with Love sending a nice super sticker. Carol, what's up, Carol? Phoenix, Mike Cunningham, True Grit Crime, Lead with Love, Nobody Nothing. It's a God Thing. What's up, Is a God Thing? Digital. Commentator Root. Lily Shaw. What's up, Lily Shaw? All right. Rebecca Ann. I don't know. Kay West is here. JoJo's here. What's up, JoJo? Cromley. What's up, Cromley? And hey, Rick H., anyone else who was here much earlier, I'm not going to go back much further, but, all of you who were here much earlier, thank you for being here early on. Thank you, everyone's here now. So this is Let's Talk Delphi. Let's do a little chat before I get out of here with the chat. Oh, KO, welcome in, KO. I didn't see you jump in, but what's up? What's up, KO? Yeah. But there's one other part I wanted to discuss before we get out of here as well. Oh, what's up, Frenchie 6290's here. It's fallen and made a batch of green chilies. Awesome, Frenchie. Okay, Nobody Nothing 1717. What's up? Okay, and everyone here, thank you for being here. Let's see. All right, let me read this last piece for you that I had, and then that'll be it for the presentation. Just one moment. Okay, let's see. I'm going to read this for you before we leave. I'm so happy to see all you long timers in here, like Radar and Frenchie Digital, Four Pits, all you guys. Thanks for being here. Kayla. Let me read this for you. The Court of Appeals is the second highest court in the state of Indiana and one of the two intermediate appellate courts in the state's judicial system. The Indiana Court of Appeals has appellate jurisdiction over all decisions rendered in any of the Indiana trial courts and decisions of any state's administrative agencies and special government groups, including the Utility Regulatory Commission and the Workers' Compensation Board and the Department of Workforce Development. The Court of Appeals must accept all appeals sent to it, except in the following cases. appeal cases that involve a sentence of either the death penalty, sentence of life, without the possibility of parole. The Indiana Supreme Court has exclusive jurisdiction over these types of cases, okay, the Supreme Court. Appeal cases where the statutes have been declared unconstitutional by any of the trial courts. These type of cases are appealed automatically to the Indiana Supreme Court. Appeal cases involving any attorney discipline, and appeal cases involving taxation. The Indiana court system consists of 5 appeal districts, and the Indiana Court of Appeals comprises 3 judges chosen from each district to form a total of 15 appeals judges. Even though the judges are selected from districts, once appointed, each judge has statewide jurisdiction. Before an individual can become an Indiana Court of Appeals judge, the person must have practiced state law for at least 10 years or served as judge in an Indiana trial court for at least 5. Court of Appeals judges are nominated through a merit selection process by the Indiana Judicial Nominating Commission. This commission comprises of the Chief Justice of the state's Supreme Court, 3 lawyers elected by the state's legal community, and 3 individuals appointed by the governor. When there's a vacancy in the court, qualified individuals that wish to be appointed as a Court of Appeals judge can vie for position by submitting an application to the Judicial Nominating Commission. These applications will be reviewed, and the top 3 applicants deemed most qualified for the judgeship position are nominated. These nominees' applications are then forwarded to the state governor, who appoints one of them to fill the vacant position. Newly appointed judges serve for 2 years, after which they'll be required to stand for a nonpartisan retention election in their district. During this election, constituents vote either yes or no to retain the judge. Judges that get a majority yes vote are retained to serve a 10-year term. Judges that wish to serve consecutive terms must stand for retention elections every 10 years. If the electorate decides not to retain a judge during a retention election, the selection process for the position will be started again by the Judicial Nominating Commission. The members of the court select the chief judge of the Court of Appeals, and this judge serves a term of 3 years. As stipulated by statutory law, all Court of Appeal judges must retire at the age of 75. Indiana Court of Appeals is divided into 5 panels with 3 judges per panel. Most senior judge in each panel is typically the presiding judge of the panel. Each panel serves together for 4 months before judges are rotated into different panels. The Court of Appeals does not conduct new trials. Instead, when an appeal is filed, the case is assigned randomly to one of the 3 judge panels. This panel reviews the case's records, including the trial court's decision and the appealing party's briefs. In some cases, the judges or the appealing parties may request an oral argument to augment the submitted briefs. When an oral argument is granted, each party is allowed between 20 to 30 minutes to present their case, which surely is a summary. After the oral arguments have been concluded and the case records have been fully reviewed, the 3-judge panel reaches a decision. This decision may either affirm or reverse the decision rendered by the trial court judge. In some cases, the Court of Appeals may send the case back to trial court for a retrial. Note that even though there is no time limit for the appellate process in the Indiana judicial system, the average time within which the Court of Appeals renders a decision after receiving a case is 4 months. The decisions that are reached by the Court of Appeals may be appealed in the Indiana Supreme Court. This must be done not more than 45 days after the decision was issued for cases where the appealing parties do not request a hearing, or 30 days after the Court of Appeals has issued a disposition in a petition for rehearing. A Court of Appeals decision is considered certified as final if the Supreme Court rejects the appeal request or affirms the Court of Appeal ruling. Remember that, because this may come into play. A Court of Appeals decision is considered certified and final if the Supreme Court rejects the appeal request or affirms the Court of Appeals ruling. The Court of Appeals decision is also certified as final if an appeal within the Supreme Court is not filed within the stipulated time period. The Indiana Clerk of Appellate Courts is the record custodian for all Court of Appeals records. Interested parties that wish to access those records may do so by contacting the Records Division of the Clerk's Office. Okay? So, one final point. Let me grab it for you. Top 7 grounds for appeals of a criminal conviction. False arrest, improper admission or exclusion of evidence, insufficient evidence, ineffective assistance of counsel, prosecutorial misconduct, jury misconduct, or sentencing errors. Let's remember this. Fruit of the poisonous tree. Bottom line, Tony Liggett lied. Tony Liggett misrepresented witness statements. That's factual. Enough said. I've covered it ad nauseum on this channel. Improper admission or exclusion of evidence. Well, sounds like we might have that in this case, doesn't it? Prosecutorial misconduct. Sounds like we might have that in this case, doesn't it? Anyhow, that's my presentation for today. I hope that you enjoyed going back over some very important points, especially the geofencing, lost 70 days of destroyed evidence, which I remind you, the prosecutor and the court has agreed is not evidence. Okay? How do we know that? No family cell phone extractions for nailing down a timeline. Ladies and gentlemen, if you don't have a timeline, you don't have a crime line. Would any of these people believe a man on the street eating his own poop, smearing poop on himself, drugged up, looking strung out, emaciated? Hell to the no, but they want you to believe because he was in safekeeping. Yeah, and on that, because you had YouTubers lying to you. Who do I mean? Who do I mean? Who's lying to you? I don't know. Turbo, Big Solves, Ruckus Rocks, Tommy Frost, etc., 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 Marv. Mana Koala was having a party on Facebook while she was medicating Richard Allen, while he was making these confessions, while he was having a psychological breakdown. She was having a party on Facebook. Is that appropriate? I didn't think so. So let me read some of your comments so I can be a gentleman and include you guys into my show tonight. I apologize. I had a lot to cover tonight, and it wasn't your normal back and forth with the chat, but sometimes it's like that. I hope you understand the mission that we're on here. And this mission is not to free Richard Allen. This mission is to seek the truth for the Delphi murders no matter what it means. If it means law enforcement is corrupt, if it means the politicians are corrupt, the judges is corrupt, the court is corrupt, if it means the family is somehow lying, misrepresenting the truth, if it means the witnesses are lying, no matter what it means we want the truth about the Delphi murders, whether Richard Allen is innocent of the crime, guilty of the crime, involved in the crime, not involved in the crime. We want the whole truth, and nothing but the truth. And when you are preventing a defense of Richard Allen, when you're preventing the mention of actual investigative product from Indiana police, and by that I mean Todd Click and Murphy and Ferenczi, rest in peace. Remember, the Odinism report is a product of Indiana law enforcement. Are you also, speaking of this, are you going to forget that now that we find Abby is dressed in clothes that Libby was not described as wearing for 7 years? Have we forgotten that tidbit too? Yeah, that's right. That's right. It's because we were lied to. Nancy Drew, welcome in. Nancy Drew, welcome in. Noe Amos. Nancy says, I missed it. Please replay. And please leave a comment down in the comment section for everyone who's on the replay. Leave a comment down there. And Nancy Drew, please leave a comment once you watch it. Yeah, the Centurion Corporation. Yeah, she was allowed to act like a 12-year-old fangirl on Facebook while treating Richard Allen in the midst of a psychological episode that includes the 61 confessions that the troll farm likes to parade all over town. And I would like you to remember, there is no muddy and bloody, there's only muddy. There is no muddy and bloody in a blue jacket that looked like Bridge Guy, because there was no blue jacket. There was a tan type jacket that was only muddy and not bloody. Remember, there was a 1965 looking Mercury Comet type of vehicle, not a modern Ford Focus. So what in the hell are we doing even discussing this anymore when we know that Liggett lied? All right. Great podcast tonight. Thank you. And thanks everyone who participated. Yeah, the chat. Thank you, chat, so much for being here. Because without you, I would certainly be here sitting alone talking to myself, and I wouldn't want to be doing that. So thank you, chat. Lies, lies, and omissions. Prof, your work is not complete yet, friend. You have blown so many holes in the case and helped shed light on the truth. We will see this through together. Well, thank you, but I only intended to make it to 100 Let's Talk Delphi's. I was hoping that that's all that would be necessary. But thank you so much. Carol, I hope not either. We have very few places to go to seek truth and support each other. I feel we've all gone through trauma from this. This could be any of our loved ones. Yes, it could be. Oh, thank you, Lead With Love, for the super sticker. Thanks for being you. Thanks for being you. And thank you for the nice super sticker. But yeah, if there's DNA, where is the genealogy? If there are fingerprints, whose fingerprints? What's up, Amy? Been a long time, Amy. Good to see you. Criminal Network. We will all have PTSD after this case. Well, I've already got it, so you guys catch up. Again, this is not anything to do. Richard Allen is the person that's in the middle of this right now. But this case is more than Richard Allen. This case is the Delphi murders trial for justice for Abby and Libby. And whether it's Richard Allen or not, what's important is the justice part. And it's just, how do you have justice when you have 70 days missing investigation, when you've had an entire investigation, by that I mean the Todd Click and Rushville investigation, thrown out. You've had the geofencing, which would show who the three people were around the crime scene at the time these girls were allegedly being victimized. How do you have a fair trial? You've had collusion between podcasters and law enforcement to spread misinformation and lies. Why is law enforcement using podcasters and YouTubers to spread lies, to leak items of their choosing, and to insert disinformation into this case? Why would law enforcement be doing that? And why would the court be allowing it? Can't bring up the Odin guards now. Exactly. We cannot bring up the fact that when Jerry Holman found out there was Norse paganism involved and the defense was interested in it, those Odin patches went away within 5 days. Can't discuss that. So they were just having friendly chats with the locals for 70 days after the gruesome double homicide. Yes. And I've reiterated several times. Those of you who have not seen the crime scene photos, try your hardest to do so. Okay, I'm not telling you how you're going to do that, but seeing those crime scene photos changes everything. And that's all I got to say about that. Is there a single Indiana official who has the moxie to do anything about this? All right. So let's see. I'm sorry I missed a lot of your comments, but Jerry Holman had a book about Odinism on his desk, and it all goes bye-bye. Gina, hey, what's up, Gina? Glad to see you back. Hi, I missed your live, but I'll replay. Please do replay, and leave a comment after it's done, please, if you don't mind. Yeah, this is what we call a railroading. You know, it's a railroading. I mean, this is a stereotypical railroading, and it's possibly even more than that. Okay. No, the photos do not prove the murders happened on that spot. The photos show an absolute lack of blood, to be honest with you. Although I believe that maybe Libby is a different situation because maybe she bled elsewhere that's not photographed. Uh, the rumor was she bled closer to the tree that you can't see. Yes, McClellan did place a gag order or beg for one, or the sealing of the probable cause affidavit because there were other actors. I read that earlier. Please watch the replay. You'll see it. Name another case, Ramsey, where the family can't be questioned. The closest people to the victims and the last one to see them. Yeah, yet you can't ask questions, and you also can't see the phone extractions because they were never done or they were disappeared. Oh yeah, and please hit like. I always forget to ask that, but this time, please hit like. Let me just do the commercial now. Please hit the support pathways, support the channel, hit like, and most importantly, listen to these points. Go look up the documents and spread the documents yourself. You need to be talking about 70 days worth of missing investigation. You need to be talking about the cops that were ignored, Ferenczi, Murphy, and Click. You need to be talking about the no family's phone information. You need to be talking about timeline problems. You need to be talking about all the things that absolutely make no sense whatsoever. And that's why you should be watching. And if you've already watched, you should take notes to figure out where these things are found in black and white, so you can shed or share these things with people who don't understand what you're talking about. When you're talking about that 70 days of recorded interviews are gone, you need to be able to show it in black and white. You need to be able to show that the family's phones were not, there exists no record of the family's phones to establish a timeline. You need to be able to show that. You need to be able to show the things that you say. Don't just go and say it. You need to be able to show that the state has geofencing that shows 3 phones malingering around the crime scene, but the state itself is asking the judge and was granted the exclusion of that very digital forensic evidence. So please, pray. Do that and pray and support the channel and support each other. And more than that, listen, there's so many people who have done so much to cause hatred, confusion, and discord amongst us all. Remind yourself why you're here in the first place. And that's to understand what happened to poor Libby and Abby and understand why they were left in the woods like that. And maybe help discover what happened to them and who did it. And that's why we're here, okay? So any discord or division that's been caused amongst us, it's because it's intentional, okay? Just consider that. Consider whose interest it would be in to keep us all fighting amongst ourselves, rather than fighting these very points that we are fighting here tonight. Anyhow, with that being said, I want you to know that I do appreciate and love you all for your own compassion for these children, for these girls. It's an admirable quality in all of you, and I want to thank you for being here for them and for that. And with that being said, I'm going to wind it down here, and hopefully we'll have more to talk about very soon on another day. But hey, do some self-reflection. If you have this hatred in your heart, figure out why and figure out how you might be to blame. Fix it. Okay, we love you. And let me say good night. Just say good night, Noe. Yeah, I see you. I see you. Good night, Radar. Good night, Sandy D. Sunflower Soul. Criminal Network. Marianne Foster. Good night, Amy. Love you, Amy. And Rebecca Ann. Cromley is a God thing. Nobody Nothing. Radar, good night. And Jojo, good night. Sunflower Soul. Phoenix, good night. Jennifer Winterwolf says, arresting Richard Allen helped get Liggett elected. And like you said, there's always reward money as a motive. There's all kind of stuff. Please hit the like, and yeah, we'll see you guys later. Cromley, Commentator Root, Carol, Kayla, Frenchie6290. All right, all of you guys, speak truth to power. That's all you can do, because truth wins in the end, okay? God bless. See you.